Okay, welcome back. So next up, we have Sean Boyle from the Cassels Graydon office in Vancouver, Canada. I grew up near the Canadian border. I always had very fond memories of Canada because you only had to be 19 to drink, so we'd go across the border all the time. It's also very progressive in other ways, though, that may be more relevant to today's presentation. They don't have any juries, except for very rare cases and criminal cases, no punitive damages. A lot of things that many people in this room might think are pretty progressive ways to practice law. Anyway, but Sean is going to talk about, first of all, Sean practices securities law and other commercial litigation, as well as compliance and anti-corruption law. He advises investment dealers on regulatory compliance and represents clients in regulatory investigations and hearings conducted by the provincial securities commissions, the Investment Industry Regulatory Organization of Canada, and the Mutual Fund Dealers Association of Canada. Here to discuss the latest developments in Canadian class actions and how they affect clients in the U.S., please welcome Sean Boyle.
Good morning, everyone. And as you've heard from the introduction and earlier this morning, the trial network is covering across U.S. but also Canada. So if you bear with me, I'm your 18 minutes of Canadian content for the day. My topic is class actions without borders, the jurisdictional reach of Canadian Securities Acts. And just as a brief primer, Canada is a number of provinces with each have their own provincial Securities Act, but they're really our harmonious passport system is what they call it. We've taken many attempts at creating a national regulator and a national Securities Act, but for reasons of our constitution and the divisions of powers between the federal government and our provincial or state governments, it continues to be regulated on a provincial basis. So today I will be speaking on a number of these issues that I'll touch on, but what I wanted to say was that you and your company or your clients may not think that you have any exposure to Canadian securities class action. But I'm here to let you know that if you are a publicly traded company, or if your client is a publicly traded company, irrespective of whether or not it's listed in Canada, you have exposure to Canadian securities class actions. And so I'm going to be touching on the definition of responsible issuer and how that creates the exposure or the connection to Canada. I then will be talking about some jurisdictionally ambitious cases from my point of view. Then cross-border scenarios and the decertification of global classes, how Morrison National Bank of Australia here in the US is affecting the certification of global securities class actions in Canada and the implications of that. And then finally, I will finish up with what I call the flavor of the month, with some trends, where we're seeing it in Canada, and how that may affect you, your company, or your clients. Traditionally in Canada, we never had and do not have fraud on the market theory. So in order to commence and be successful with the securities class action, individual reliance of each of the investors was a necessary element to prove at trial. Clearly, that is something that is very difficult for plaintiffs' counsel, and that effectively barred the class actions in this area. But 7 years ago in Ontario, 5 years ago in British Columbia, and different time periods across the other Canadian provinces, Alberta, Saskatchewan, and the Maritimes, there was a legislative changes. And the legislative changes created a statutory cause of action. So not a common law cause of action for a negligent misrep or something like that, but a statutory cause of action where there was deemed reliance. So what we had starting 7 years ago at the earliest point was if there was a misrepresentation by an issuer or by a director officer of that issuer, whether in their core documents, their circulars, their prospectuses, or indeed in oral statements at seminars like this or in press releases or news conferences, there was now a deemed reliance, and individual investors didn't have to prove that issue. Importantly, the other element we don't have is there's no scienter requirement. So the causes of actions can be simple negligent misrepresentation, just a simple mistake. The CEO can be having a bad day, they can be having family issues at home, they can be giving a news conference outside of a shareholder meeting, and that can form the basis of the class action. This graph deals only with the statutory causes of action, starting in 2005. And you'll see the cases before 2005, that related to misrepresentations in the prospectus documents or circulars where there was summed reliance that could be deemed that if you invested on the basis of a prospectus, clearly you were deemed to have read that prospectus. And what this table tells us is that cases are becoming at an all-time high, and they're growing since this was May 2013. This, as I said, doesn't form the basis of other class actions. We have hundreds and hundreds of product liability, pharma class actions against all the major Coca-Cola, Microsoft, Yahoo, Google, Facebook. They're all being sued in Canada, all for different causes of action that you would see here in the U.S. But this is under the Securities Act, the statutory cause of action. What this says to me is that when this new act was coming forward, lawyers and commentators published articles and stories saying this was going to be litigation unleashed. We were going to move directly into the U.S. realm of strike suits and numerous frivolous class actions. That didn't happen. And it didn't happen in 2005 and 2007, primarily in my view and the view of a lot of commentators in Canada, was because our plaintiffs' counsel didn't have the experience. And what happened here in recent years is literally there was one individual, a plaintiff's lawyer who earned his stripes working here in New York at a large international firm defending securities class actions around the world. And he decided this defense side in New York, that was interesting, but I'm going to move home and I'm going to go on to play for the other team and I'm going to commence the plaintiff side. And this fellow has had success. The settlements back in 05, 06, 07, the insurance companies wanted to settle. They looked at the defense costs of defending one of these claims, and they made settlement offers in the millions of dollars. But what's happened since then is now our settlements are now in the tens of millions of dollars, and more recently, they're now in the hundreds of millions of dollars. And so what we're seeing across Canada with a lot of my colleagues, securities litigation partners at large national or international firms, are saying, that's interesting. I think I might want a piece of that $100+ million settlement on the contingency side. And we're seeing lawyers on the defense side primarily, because the cases haven't been coming into at a great extent, are switching teams and are commencing the plaintiff side class action. The 53 cases this year represent about $23 billion in dollars claimed. So although, as John said, we do have jury trials for some cases, not class actions. We do have some punitive damages. Typically, they're capped at about $1 million or $2 million. But we're now seeing settlements on the security side in the hundreds of millions of dollars. Just a brief slide about where the filings are. What I take from this, and may not be surprising given Canada's industry and our exports, is that you'll see that non-energy minerals, basically energy, natural resources, mining, oil and gas represents a large portion. But of course, the financial sector also represents in excess of 25% of the claims. All of the Securities Act have to provide some grounding to the Provincial Securities Act for a class action, a securities class action to be commenced against you or your client. And this is the provision that's found in all of the acts, and it's the definition of responsible issuer. And a reporting issuer, for those of you that don't know, is simply a reporting issuer where they would have their securities filings with a provincial regulator, like you may have a securities filing here with the SEC. But it's the sub B that has opened the playing field. And that's any other issuer with a real and substantial connection to any Canadian province, any securities of which are publicly traded. So if you stop and think about that for a moment, and I'm going to take you to a few cases, your company may not be traded on any exchange in Canada. You may be traded on NASDAQ, or indeed you may be traded on the Australian Stock Exchange, the Oslo Bourse in Norway, or some other exchange in the world. But if there's a real and substantial connection to Canada, if it has a mining property, if it has a subsidiary that's a Canadian corporation or a Canadian provincial corporation, and there's sufficient facts that exist that there's a real and substantial connection, they can be sued under the Provincial Securities Act with the deemed reliance in Canada. So that gets us into, in Canada, what is a real and substantial connection? My understanding is it's not dissimilar from here in the United States. The defendants would say, well, they're not selling or promoting securities in the province. You know, they haven't made misrepresentations. If all their securities filings have been with the US SEC, or as I always like to, with the Oslo Bourse in Norway, then how can there be a misrepresentation in Canada? That there has to be some connection. But as I said, the plaintiffs have said, no, you own some moose pasture up north, you have a Canadian subsidiary, you have an office in Canada, or you have some employees, or indeed you may have an online presence in Canada, that may give rise to a real and substantial connection. Abdullah and Canadian Solar is a case that I've touched on before, and last year at this conference. It had not reached the Supreme Court of Canada when I spoke last, and indeed it has since then. And I regret to inform all of you that the Supreme Court of Canada refused to reverse it. The facts of Canadian Solar are that it traded exclusively on NASDAQ. It reported only in the US. So all of its securities filing were only in the US. There was no securities filings in Canada, but it did have a head office and principal office in Ontario. It carried on business primarily in China, and we know that because it's called Canadian Solar as a company. It was a joke. That's not unusual to have a number of, especially in Vancouver, British Columbia, where I'm from, we have a large Chinese presence and a large business relationship with mainland China. And we'll see a lot of the Chinese companies have an office registered in Canada and have Canadian or a Canadian sounding name in their company name to assist them with their public relations. And so those were the connections. Those were the connections for Canada, and our court said, no, that's sufficient. It meets the responsible issuer test because it's traded on an exchange, albeit in a different country. There's a real and substantial connection, and they were free to commence the claim. And so, of course, they're relying under the Securities Act of Ontario and the deemed reliance and all of the benefits that provides, although they have there's no other connection or no other obligations that they have under that act. And so they have no obligations, but they're getting the benefit of the deemed reliance. It's important, and I thought it was important to touch on the real and substantial connection, because since the Canadian Solar case came out, before the Supreme Court of Canada heard it, this case, Club Resorts in Van Breda, was heard by our Supreme Court as well, and it was in a different context, in a personal injury context, where a resident of Canada was injured while vacationing in Cuba, and the court considered whether there was a real and substantial connection, and they looked at the test. In that case, the plaintiffs have the onus of establishing a presumptive connecting factor, and the failure to establish that presumptive connecting factor would end the inquiry. And nevertheless, though, if the connecting factor is established, then the defendant can still rebut it. I raise it because I think it may be relevant to future securities cases. So plaintiffs suffering damages in a jurisdiction is not a presumptive factor, but the contract being formed. And so, as I said, one of the issues that you, your client, or the company that you're with may have to wrestle with is whether or not they're carrying on business in Canada. And you'll see that there's some examples at the bottom there of the slide. The virtual presence may not be enough, but if you have an office, if you own real property, that is likely sufficient to rebut the presumption. Briefly contrasting the US experience, I know you're all familiar with the Morrison National Bank of Australia case, established the bright line test, rejected the prior conduct and effects test, and now, in my view, the Canadian courts have a broader jurisdiction. This is pandering to the local market, but I believe it to be true. The US courts got this one right with Morrison National Bank of Australia. In my view, there's no unfairness, there's the bright line, and you, your company, your clients know that if you're going to be traded on a US exchange, you're going to be regulated by the Americans, you're potentially facing class actions. To use my example, if you're traded on the Oslo Bourse, how can you possibly have an expectation that you'll be facing a potential class action under the, for example, the Saskatchewan Securities Act? Saskatchewan, for those of you who don't know, is where I'm from, north of Montana, North Dakota. And the court's got this right because obviously the potential for overreach in the jurisdictions is immense without the bright line test. And the overreach is evidenced and exemplified by what I call some accidental tourists that have found themselves sued in Canada. The Juniper AIG case has been commenced a number of years ago, but again, traded exclusively on the New York Stock Exchange. Minimal contact with Canada whatsoever other than some indirect subsidiaries. And in that case, through the work of counsel, both on the plaintiff side, because there's some benefit for not expending the effort in proceeding, they've reached a consent staying the matter while the U.S. matter proceeds. This is one that I find interesting. You may recall British Petroleum had a disaster in the Gulf. It was sued here in the U.S., but as a result of Morrison Bank National Australia, the trades on the London Stock Exchange were removed from the class proceeding, leaving only a small class of ADR purchasers. So what do plaintiffs' counsel do? They go to Alberta, Canada, where of course British Petroleum has oil and gas projects. They have some retail outlets. That was dismissed in Alberta on jurisdictional grounds, but they've recommenced in Ontario, of course, on the basis that BP is a publicly traded company. It has a connection to Canada. Therefore, the correction of their prior misrepresentations about their safety regulations ought to be heard in Ontario, Canada. A further accidental tourist is the recent cases against Facebook. They've been commenced in a number of provinces, in 4 or 5 provinces in Canada. And what I particularly enjoy, and I'm being facetious, is they've made claims in connection with its initial public offering. That initial public offering, of course, was not open to Canadians. No one could have participated in it from Canada, but the class actions proceeding, and there they are. There Facebook is finding itself necessary to defend itself in 4 provinces in Canada. There is some good news coming out of this. And as you may know, the cross-listed, interlisted companies is common. We have the multi-jurisdictional system, and we see a lot of parallel actions. A lawsuit will be commenced in California, for example, against Google. A similar actions commenced in British Columbia, Alberta, Ontario. What we are finding is some flexibility when dealing with Morrison National Bank of Australia. For example, the Silver IMEX class action was commenced in Canada, certified as a global class because it was traded on the TSX, and it was also commenced in the US. In 2012, I think it's Judge Buchwald of the Southern District of New York dealt with the settlement of purchasers or investors over the US exchange. They came back to the Canadian judge that certified the global class, and they decertified the 85% of the plaintiff investors who traded on the US exchange. And so there is some willingness by the Canadian judges to revisit that. In conclusion, I just wanted to touch on a couple flavors of the month. We are seeing an increased claim against underwriters. If that's your business or your client's business, you will likely find yourself as defendants in Canadian class actions. Likewise, the auditors. There is a big push by both plaintiffs' counsel and the regulators to go after the auditors. The E&Y settlement of $117 million in connection with Sino-Forest, that you may recall was the Chinese company that turned out to be a fraudulent, basically a fraudulent business and their representation. The OSC, the Ontario Securities Commission, the British Columbia Securities Commission, where I'm from, they're going after the auditors. The plaintiffs' counsel have them in their sights, and that's something that that you and your client should be aware of. Thank you very much.